Yep. All right. Good morning, everyone. Looks like everyone's at the table. My name is Jonathan McGrath. Welcome to the 10th meeting of the National Commission on Forensic Science. I'm the designated federal official. And before we get started, I'm going to read a couple housekeeping items just in case of emergency evacuation. We are in the main conference room. In the unlikely event of a situation requiring emergency evacuation of this building, the following procedures should be followed. If you hear an alarm from anywhere in the building, you should begin evacuation. Stay calm and gather any personal belongings. Do not take any food, beverages with you when you leave. Please leave them behind. Exit in it. Unless otherwise directed by a stairwell monitor, exit through the door in the back of the room, located over here. Do not exit using this door through which you entered the room. Exit in a calm, orderly manner. You will exit the building onto I Street. Move away from the building. Follow instructions from OJP designated employees who will be wearing orange vests, and designated employees will notify you when all clear has occurred to return in the building. With that being said, I'm going to turn over the opening remarks to Dr. Whedon and Dr. Butler.
Well, I'm not a doctor, so I guess I get forgotten. So good morning, everyone. I just want to welcome you formally to our 10th meeting, also to the folks on the webcast. Also a belated Happy Father's Day to those fathers in the room, and I apologize for those who had to travel. So anyhow, let's start the meeting. Just a couple of notes before I turn it over to John. First of all, thank you for working so hard over the last 90 days to actually accomplish quite a bit. I believe we have 9 work products to vote on and several others that are going to be introduced. So I don't know if it had anything to do with the presentation I gave last time, but I'm very happy on the progress that we're making, and I think we're very close to meeting our goal. As you can see, just very quickly, today is primarily presentations on a variety of topics, and tomorrow is a lot of the business of the commission that we need to get done. So I ask you folks to please, if you haven't looked at the documents carefully, be ready to discuss them tomorrow, because we have a lot to go through, and we're not going to get to everybody's questions, as you know. So hopefully we can address these things quite efficiently so we can get through them tomorrow. And like I said, tomorrow is just going to be a busy day from 9 to 5, just going over work products. So with that, again, welcome, and I'll turn it over to John for some comments.
Just wanted to review the outline for the day quickly. So we have opening remarks from DOJ that Victor Whedon will give on behalf of Dag Yates. Willie May, unfortunately, is, just got back from a trip and is unable to be here, so I'll give the opening remarks for NIST. Then we'll have the Office of Legal Policy. We'll talk about the Forensic Science Discipline Review, and then we'll take questions at that point. Then Jonathan McGrath will review the SPO standards and procedures operations, right? The subcommittee on procedures and operations status report. We'll have a working lunch on certification and licensing panel, and then we'll have the public comment period. And then this afternoon will be the close to the public subcommittee meetings. So with that, I'll turn it over to Victor Whedon.
Welcome. The Deputy Attorney General, Sally Q. Yates, wishes to express her regrets in not being here personally, but she is a scheduling conflict and has asked that I speak for her today. Before I begin with my remarks, I want to pause to recognize the horrific events that happened in Orlando. On behalf of the Deputy Attorney General and everyone at the Department of Justice, our hearts go out to the families of those who have been killed, and our prayers are with the wounded and the families and friends of the victims. As the Deputy Attorney General said, the full resources of the Department of Justice, including the FBI, the ATF, the National Security Division, and the U.S. Attorney's Office for the Middle District of Florida, are supporting the ongoing investigation. I also want to recognize the efforts of one of our own commissioners, Catherine Turman, who serves as the director for FBI's Office of Victim Assistance. She's on the ground in Florida as we speak here now today, and we're grateful for her work during this challenging time. I want to begin by introducing myself and the DOJ team that supports this commission. In the past meetings, Dag Yates has spoken about the importance of building a team a team of experts at DOJ to support and strengthen forensic science policy. And I'm pleased to be a part of that growing group of individuals. Dag Yates introduced me at the last meeting. I am Victor Whedon, and I have been detailed from the George Washington University to the Department of Justice as the Senior Forensic Advisor to the Deputy Attorney General. As many of you know, I recently completed a term as President of the American Academy of Forensic Sciences, and it's a pleasure to be with you all here today. You probably, Jonathan McGrath, you had opened the session. You probably noticed that Jonathan has replaced Andrew Bruck as the Commission's designated federal officer. Dr. McGrath serves as a senior policy analyst with the Department's National Institutes of Justice, Office of Investigative and Forensic Sciences in Washington, D.C., and has been supporting the Commission's activities since joining the Department in March of 2015. Prior to joining DOJ, he served 8 years with the U.S. Customs and Border Protection Laboratories and Scientific Services, first as a forensic scientist at the CBP Southwest Regional Science Center in Houston, Texas, and then as a science officer at the CBP Laboratories Headquarters Office in Washington, D.C. Dr. McGrath has a B.S. in chemistry, a Master's of Science in Forensic Science, and a Ph.D. in analytical chemistry. Dr. McGrath has been working closely with all of you for several months, and we are appreciative that the NIJ has permitted him to serve as the DFO for this group. We believe there is no one better suited for this position, and the DAG personally thanks you, Jonathan, for taking on this challenge. Lindsay DePalma, is she here? Yeah, there's Lindsay. Can you raise your hand, please? There. Yeah, serves as the NCFS Program Manager. Ms. DePalma works as a technical consultant to NIJ's Office of Investigative and Forensic Sciences and has previously supported many of NIJ's DNA initiatives. She holds a bachelor's degree from James Madison University in Integrated Science and Technology and a master's degree in biotechnology from Johns Hopkins. She worked at a private biotechnology company overseeing gene therapy trials before coming to NIJ. Andrew Bruck is behind me. You want to raise your hand, Andrew? Is now serving as Dag Yates' acting Chief of Staff. And he will continue to work with me and others on the forensic science issues. The DAG personally thanks him for his past and continuing efforts. Please also allow me to reintroduce Jonathan Wroblewski, there you go, and Kira Antel, and Shamika Gaskins, is she there, Shamika? All of the Office of Legal Policy. They are a dedicated and talented team. They figure prominently in DOJ's forensic science efforts and the responses to this commission. They also were key to the developments of the uniform language for testimony and reports and the forensic science discipline review methodology that I will return to. We have two new commissioners with us today. Rebecca Farrell, would you raise your hand? Ex officio NSF representative, Dr. Rebecca Farrell. Mark Weiss recently has retired and requested to step off the commission. To take over his role as our commissioner is Rebecca Farrell, Ph.D. Dr. Farrell is currently the program director of the Biological Anthropology program at the National Science Foundation, where she also serves as co-lead of the NSF's forensic science efforts. Dr. Farrell specializes in skeletal and dental anthropology, and since arriving at NSF in 2014, Dr. Farrell has managed a diverse research portfolio. She is currently working with colleagues across the NSF and at other agencies to identify and cultivate basic research with relevance to forensic science and to launch a forensic science industry university cooperative research center. Troy Lawrence, could you raise your hand? Digital Evidence Commissioner Sergeant Troy Lawrence. As you may recall, Bill Crane recently took a new job overseas and resigned his commissioner seat representing the digital evidence community. To fill his seat, the Attorney General has appointed Sergeant Troy Lawrence. Supervisor of the Digital Forensic Laboratory in Fort Worth, Texas, the police department there. Sergeant Lawrence is a 28-year veteran of the Fort Worth Police Department. He began his forensic career in 2000 and developed the Fort Worth PD's Digital Forensics Lab, which started as a one-person, part-time position and now currently maintains 6 examiners who process computers, mobile phones, and forensic video. He is the director of the training for the International Association of Computer Investigative Specialists certification body, and has previously served as a peer review coach, certification regional manager, chairman of the recertification committee, and secretary on the IACIS board of directors. We're pleased that Sergeant Lawrence can provide the perspective not only of the digital forensic community, but also the views of the state and local law enforcement community, which is so crucial to the work that we do. It's a busy time for forensic science at the Department of Justice. We have several projects in development or underway, and I thought it would be helpful to provide an update. In the last few months, we've been particularly active in examining how forensic science evidence is described in the courtroom. We have 2 projects, one forward-looking and one backward-looking, that we're developing simultaneously. They are distinct projects, but closely related. The forward-looking project involves the proposed uniform language for testimony and reports, which we simply call the ULTRs, or the uniform language. As I'll explain more in a moment, this is an extension of the FBI's multi-year effort to develop standards for testimony and reporting for a variety of forensic science disciplines. We anticipate that once finalized and adopted, the uniform language documents will govern what DOJ's forensic examiners can and cannot say when testifying in court or drafting a report. The first batch of proposed uniform language documents were released for public comment 2 weeks ago, and we anticipate another round later this summer. The backward-looking project is the Forensic Science Discipline Review, or FSDR. As you'll recall, Jonathan Wroblewski presented a framework for the FSDR at the March NCFS meeting, and you'll be hearing a more detailed overview of the proposed methodology later today. This project is designed to examine historical cases in a manner similar to a quality assistance review. Later this week, we expect to release a written summary of the proposed methodology for public comment, which we plan to review and incorporate before presenting again to the Commission at our September meeting. These 2 efforts, the uniform language and the FSDR, are part of DOJ's ongoing effort to ensure that the practice of forensic science is grounded in sound science and presented to judges and jurors in a scientifically valid manner. Although DOJ is spearheading these efforts, we are working hard to ensure that the broader community, scientific and legal communities, are involved throughout the process. That includes scientists and practitioners, academics and advocates, and our partners in state and local law enforcement. Dag Yates has made clear that the development of both the uniform language and the FSDR should occur in a thoughtful, transparent way. At each step of the process, we have sought and will continue to seek public comment, not because we are required to, but because we genuinely believe that input from others makes our work stronger. There may be occasional disagreements over substance, but we can always agree on the value of an inclusive, collaborative process. Let me provide a bit more detail about the Uniform Language Project. Earlier this month, DOJ announced the release of the first batch of proposed uniform language in the Federal Register, which are now open for your comments and input. As I mentioned before, the proposed uniform language specifies what department forensic experts can and cannot state in laboratory reports and courtroom testimony, based upon sound science for 7 forensic science disciplines, specifically fiber, footwear and tire treads, general chemistry, glass, latent prints, serology, and toxicology. Later this summer, we plan to post another batch of proposed uniform language documents for other forensic science disciplines, including firearms, explosives, DNA, hair analysis, and handwriting. After reviewing and responding to public comments, DOJ hopes to finalize and approve these documents later this year. Once issued, the uniform language will apply to all DOJ forensic examiners at the FBI, ATF, and DEA. The uniform language is based on the FBI's approved standards for scientific testimony and report language, or ASTRS, which the FBI has been developing over the past several years and which Dag Yates and others have discussed in the past. Earlier this year, we decided to broaden the scope of this effort so that the standards would apply not only to the FBI, but also to our other investigative agencies as well. In addition, we decided that before adopting these documents as final, we would seek input from this broader community. Although the uniform language documents, as approved, will only apply to Justice Department personnel, the Department nonetheless decided to release the proposed documents for public comment. As the documents make clear, the uniform language documents are not intended to serve as precedent for other forensic laboratories and do not imply that statements by other laboratories are incorrect, indefensible, or erroneous. These documents are now available for public comment through midnight on Friday, July 8th. Copies of the proposed uniform language documents are available for review at www.justice.gov/forensics, and public comments may be submitted online through www.regulations.gov. Please note that all comments will be made public. At the last Commission meeting in March, the Department's Office of Legal Policy presented a very general framework for forensic science discipline review, and then asked for public comment. DOJ received thoughtful comments from many stakeholders. You'll hear more from OLP shortly when they present further details on our current thoughts on the FSDR methodology. But I want to emphasize that the review of testimony is intended to provide a department-level review and feedback mechanism for the status of forensic testimony, and not because there is any indication of systemic issues. The actual proposed FSDR methodology will be posted later on our website, www.justice.gov. I hope that you will provide us with significant input on this important effort, also through the www.regulations.gov website during the public comment period. I'd also like to provide updates on Commission activities. At the March meeting, we had a very productive discussion about prioritizing the most important issues to maximize our efforts before the NCFS charter expires next April. As we have said in the past, we are hopeful that the Commission continues in the future, but we cannot predict whether the next administration will decide to renew the charter or not. It's also important that we prioritize our efforts during this difficult budget environment. DOJ is eager to support a broad array of efforts to strengthen forensic science, but we must be aware of our finite resources. As you may know, Congress is currently working through appropriation bills for the upcoming fiscal year, which starts in October. It's worth noting that the current House bill would eliminate funding for this commission for the next fiscal year, which is an important reminder of the challenges we face. Last week, we circulated the Attorney General's memo responding to NCFS work products adopted 2 meetings ago at the December 2016 meeting. Recommendation to develop a forensic science curriculum. The Attorney General, Loretta Lynch, agrees that additional comprehensive and balanced forensic science curricula could improve the legal practice related to forensic science. DOJ will transmit the NCFS's recommendation on forensic science curriculum development to appropriate researchers, statisticians, scientists, and legal organizations, and ask the individuals and organizations to consider developing responsive training. She has directed department litigating entities to review the forensic science training available to department prosecutors to determine if new training should be developed or if training protocols should be instituted. And she has directed components to explore where there are opportunities to further distribute existing department-generated forensic science training materials, or where it may be able to support the creation of new responsive training materials. The views documents. The Commission also voted to adopt 2 views documents, one on forensic analysis based on task-relevant information, and the other on documentation, case record, and report contents. In accordance with Commission bylaws, the Department will not respond to them. Medical legal death investigation. You may recall that the AG referred previous recommendations on medical legal death investigation to the White House Office of Science and Technology Policy, or OSTP. An OSTP Fast-Track Action Committee on Strengthening the Medical Legal Death Investigation System had previously formed and recently issued a draft report for public comment on improving MDI data systems. The OSTP is following that effort with a new MDI working group that I will co-chair with Chris Jones of the DHHS and Eleanor Celeste of the OSTP. This is an area that has captured the attention of the White House, and the MDI recommendations will be considered there. The amount of work products produced by this Commission is increasing. At the March meeting, 8 documents were approved, half of which were recommendations and half views documents, some of which involve more deliberation than others. Please recognize that processing these recommendations in a timely manner is a priority, but the complexity of the March recommendations combined with the Department's forensic focus on development of the SDR methodology and the uniform language process creates a challenge to us. We will continue to work to review and respond within 6 months. Future of the Commission. The House Commerce, Justice, Science, and Related Agencies Appropriations Committee has issued a budget that does not include funds for this Commission and remarks that the administration's Forensic Sciences Initiative lacks the involvement of state and local practitioner community. I would point out the following. While the Department estimates that funds are currently available to hold quarterly NCFS meetings until the completion of the current Commission charter in April 2017, the Commission's continuation beyond then will depend upon support from a new administration. We appreciate your valuable efforts to improve the forensic sciences in this country. Thank you.
You got something, John?
So I have just a few slides to share if I can get my slides back. Just as a NIST update, as I remarked earlier, Willie May unfortunately is unable to be here today and sends his regrets to not be able to speak. So I just want to share some of the slides that we had planned. Just as tomorrow afternoon, the Scientific Inquiry and Research Committee subcommittee is going to discuss the documents that have been prepared by the subcommittee, and NIST provided about 6 weeks ago provided some input to the subcommittee, and I want to just mention that. So first, the first bullet I have up there is that the ISO IEC 17025 just points out that validation is the confirmation by examination. So it requires that you use data, of course, to define the capabilities and limitations of any measurement methods. NIST does not plan on trying to provide a detailed evaluation of every forensic method or practice. That was never what we have the capability to be able to do. So what we've talked about is that we would initiate a series of invited reviews written by NIST scientists or others that could help with examining the scientific underpinnings of select forensic disciplines. This is what's been discussed before and as part of the MOU that we'd look at select forensic disciplines. And one of the things that's been discussed as part of that is that we'd have, with the publication of resource documents that would discuss these things, looking at the scientific validity of different methods, it would also be accompanied with some, or could be accompanied with some with some judicial training go with that. The details of how that worked out is just, right now, it's just concepts. So what we propose back to the subcommittee is that we would focus efforts in 3 areas: bite marks, which NIST doesn't have any experience in, but would work with others on that, firearms and tool marks, and DNA. So those are the kind of the 3 pilot proposals that were given back to the subcommittee. The other thing that, just to point out, is that if you look at the overall process in terms of forensic investigation from the point of collection of evidence all the way to testimony, NIST expertise, of course, lies in measurement science. And so the expertise rely mainly in the detection and analysis phase, a little bit into interpretation. In order to be able to do these things, that's why we propose doing some pilot projects, looking at what are some of the challenges of even producing these types of documents. This would, of course, to do this in more detail and more disciplines would require additional funding and resources to be able to do that, but this is what has been just described back to the subcommittee. In terms of how information would be shared, these are some of the ideas we're looking at, whether it be a book chapter, which is what Willie May described last time, or a NIST report in some format, or the Journal of NIST Research. And we provided back to the subcommittee this kind of outline where we have an introduction of the scope of the evidence types and conditions, what would be measured and compared, what's the parameter that would be analyzed, the nature of the features being compared, and then what are the current approaches for repeatability and reproducibility. Another option we've been looking at is the journal Metrologia, which is a journal, international journal for measurement scientists, metrology journal. And it has all kinds of, we've talked to the editor of this journal, as this is another option to kind of to put things out on an international scale. So we're just looking at ways that once these types of documents are written up, how can we share them with the community? So other discussions that NIST has held, we went up to the Innocence Project at the beginning of May and met with them and talked about some of the issues and challenges we face. Also, the President's Council of Advisors on Science and Technology invited several NIST people to participate in a May 20th meeting and talk about some of the issues with evaluating forensic disciplines. So we just want to make you aware of some of those discussions. Another point is just with OSAC. Last time there was some discussion about the OSAC registry and some of the growing pains, some of the lessons learned from this. So there's a lot that's been learned as we've looked into what came out of what was mentioned at the last meeting, the ASTM E2329, the seized drug standard. One of the things we've been looking at is the review of the ASTM balance requirements and try to improve stakeholder participation. Some of the challenge that happens with the interconnectivity of many standards that are in play, and then the need to get more researchers and metrologists, statisticians involved. And so a lot of outreach has gone on trying to get more people involved. On this Wednesday, on June 22nd, there's going to be a meeting of a focus group from the OSAC participants to try to strengthen the OSAC processes and communication. So these are some of the things we're looking at. Of course, strengthening the technical merit checklist, regularly convening the NIST experts to look at documents, and a statistician task group weighing in on their options and opinions. The next meeting, the NCFS meeting 11, will be held at NIST in Gaithersburg, and so we wanted to we're excited to hold that there. And then as part of that, we'll be doing a few tours probably at the end of the subcommittee time period is what we're looking at on the first day, but to be able to have the opportunity for you to see a little bit of the NIST campus. And so you get a perspective of some of the things NIST is working on. Just last week, we actually opened an exhibit, a museum exhibit on forensic science work, some of the early forensic science work that was done back in the 20s, 30s, 40s, and 50s at NIST. And so that'll be something you can see as well when you come to Gaithersburg. So we're excited to have you there. And then the last thing is just at the end of this year, calendar year, November, there'll be a Forensics at NIST conference. And so there'll be an opportunity to showcase the research that NIST is doing, as well as hearing from NIST Forensic Science Center of Excellence and the efforts that they're doing. So that's what the prepared slides we had, and I can help with answering questions later after the OLP talks. So.
Okay, let's move into the FSDR presentation.
Good morning, everybody. Good morning. The slides. We don't know? While we're waiting, maybe I should just introduce myself and our team that's working here on the Forensic Science Disciplinary Review. My name is Jonathan Wroblewski, and I am the head of the Office of Legal Policy, and I'm very, very fortunate to have a wonderful team that's participating with me. First to my right is Shamika Gaskins, who is the acting Deputy Assistant Attorney General for Policy. Next to her is Kevin Scott, who's the head of our data analysis unit, our very, very small data analysis unit, and next to her is Kira Antel. Also, I just want to mention John Gould, who just joined our office, who is on the faculty at American University, who is also participating. So we're very, very glad to be back here before the Commission to update you on the FSDR and the work that we've been doing over the past few months. Before I start talking about the FSDR, I want to thank those of you who commented on the framework that we presented last time. The comments were very, very helpful. If you haven't had a chance to look at those comments, please do, because it gives you a little bit of a preview of the different perspectives that I'm sure we're going to hear. We already began hearing back in March on different aspects of the draft of the methodology to be used as part of the FSDR. What we'd like to do today first is to present what we've been up to with a focus on the methodology development. Kevin will then outline for you our draft methodology, and we'll also lay out our path forward. And of course, after we're done talking, we'd very much like to get your comments on all of this. Right. So there's our team. We're having trouble moving the slides. Okay, so here's a little outline of the presentation. I will first start with giving some background on the Forensic Science Discipline Review. Kevin will then lay out a little bit about our draft methodology, and we'll also talk about some other elements for comment. So as Victor mentioned, and as you probably all recall, back in February, the Deputy Attorney General announced that we would be undertaking this review. It came as a result, in part, of concerns that were raised with testimony related to microscopic hair analysis. Our goal here is to ensure, as Dr. Whedon said, our goal is to ensure that forensic science used in the courtroom is consistent with scientific principles and just outcomes. And what we're trying to do here is to learn and understand how testimony is being presented in court in recent cases, and then to facilitate any necessary steps to ensure that, in fact, expert forensic testimony is consistent with scientific principles and just outcomes. So over the last several months, we've been doing a whole lot of outreach, and we've met and spoken with many of you. We have been speaking mostly with experts outside the Justice Department. We have spoken and spent a lot of time with our colleagues at the National Institute of Justice and the Bureau of Justice Statistics. We have also spoken with folks from NIST, from CSAFE, the Innocence Project, NACDL, the National District Attorneys Association, the forensic community, and many, many others. We have also undertaken a literature review to understand previous reviews that have been done of forensic testimony. And from all this, we're working towards our proposal and our methodology. And as of now, our proposal is to review forensic testimony presented by FBI examiners in a variety of different forensic disciplines in state and federal cases over a 5-year period from 2008 to 2012. The reason we selected this particular 5-year period is, again, our goal is to try to learn what's going on in the courtroom now. And we don't want to get in the way of cases that are ongoing, and that's why we didn't go as late as 2016. On the other hand, we don't want to go much further back than 2008. And so tentatively, we are looking at examining testimony from the period 2008 to 2012. The disciplines that may be involved in the review are listed up here on the slide. As Dr. Whedon said, the choice of disciplines to review are not based on any particular specific concerns about any of those disciplines. However, these disciplines were identified in the National Academy of Sciences report a number of years ago, and has also been identified by a variety of folks who we've spoken with. Now, as I've said, we've consulted broadly since our last meeting, but we want you to know that any and all comments are welcome. We encourage all of you, whether we've spoken with you or we haven't, to review the draft methodology and to provide written comments. Our objectives in developing the methodology is, number one, transparency. We think that to make all elements of the methodology fully available for review and public comment is going to lead to a better review and is also going to lead to greater public trust and confidence in the review. As Dr. Whedon mentioned, we hope by the end of this week to post the draft methodology online. That's the full text of the methodology, not just the slides that we're presenting today. And to have a period of public comment from 30 to 45 days. We also want to be, in putting together both the draft methodology and all the work around the FSDR, as independent as we possibly can be within the Justice Department. And so our team has been working independent of the labs and federal prosecutors. We think that's the best way to avoid or to minimize any bias. We also, again, want to bring to you, to this commission, for review and consultation, all of our steps on the way to beginning this review, including our draft methodology, our framework, and then our hope is to present a final methodology to you in September, and so we can get going with all of this. So here's where we've been. In March, we presented the framework. We received comments through May, which very much informed our development process. We have been working over the past several months to develop a draft methodology, which we are going to be presenting now. Moving forward, later this week, we hope to post the draft methodology for public comment. We are then planning to hold what we're calling a statistician roundtable. We have heard from many stakeholders a very, very keen interest and a desire to have statisticians involved in many, many different aspects of this review. And we want to do that. And the way we've proposed to do that initially, anyway, is to have this roundtable, and we have begun inviting statisticians to spend a full day with us in July to go over various aspects of the methodology, the uniform language, the language that we will be using for the as standards for this review, and other issues related to the review. Following the roundtable and the comments on the draft methodology, we're planning to revise our methodology and present to this commission in September what we hope will be a final draft of the methodology for review and comment and consultation with this commission. And our hope, once we finalize the methodology, to begin the FSDR review either later this year, I think more likely beginning next year. As Dr. Whedon mentioned, and as you all know, the department published the uniform language for testimony and reports. These are standards for use prospectively in testimony. They were based on the FBI ASTRs. And as Dr. Whedon said, we have published 7 different disciplines. They are out for public comment, and more uniform language documents will be coming later this summer. Now, one thing I do want to mention is that the standards that we're going to be using for this retrospective review, the FSDR standards, they will likely, in some cases, be different because the science has been changing. We're not sure. We think that the uniform language will form the starting point for the FSDR standards, but there may be some tweaking, and our expectation is that at least one FDR testimonial standard can be presented to this commission in September, and other standards to be presented to the commission in subsequent meetings. With that, let me turn it over to Kevin, who can begin walking you through the draft methodology.
Good morning. In addition to OLP staff, research experts from the National Institute of Justice and the Bureau of Justice Statistics, both of the Department's Office of Justice Programs, participated in the development of this draft methodology. OLP particularly thanks Chris Tillery, Joel Hunt, and Linda Truitt of NIJ, and Matt DeRose of BJS for their participation. The FSDR seeks to assess how closely FBI examiner statements of relationship in the selected disciplines conform to FSDR adopted testimonial standards. Jonathan has already touched on discipline selection and on the FSDR standards, so I'd like to start with the discussion of statements of relationship. Because the interest of the FSDR is a general one and not driven by a concern with a particular discipline, we believe it appropriate to look at all statements that express a relationship between a piece of evidence whose origin is known and a piece of evidence whose origin is unknown, or two pieces with unknown origin. Those statements can take 3 general forms: statements of association, where the examiner concludes that the known and the unknown pieces of evidence have the same source; statements of exclusion, where the unknown is determined to come from a different source than the known; and an inconclusive statement, where the examiner cannot determine if the known and unknown evidence have the same source. Our focus on all statements of relationship is one important distinction between the FSDR and previous reviews. And our work here was informed by the FBI's microscopic hair comparison analysis, the work of the Texas Forensic Science Commission, and the work of the New York Commission on Forensic Science. These reviews focusing on hair evidence have generally focused on both reports and testimony and have been restricted to cases where there was a positive probative association and where the defendant was convicted. The FSDR, on the other hand, proposes to look at all testimony, all statements of relationship, not just positive associations in those testimonies, look at all cases between 2008 and 2012, regardless of the outcome of the case. We believe these choices best reflect the goal of the FSDR that Jonathan outlined earlier. One thing I want to note here is that we plan to look at testimony both in federal court and state court by FBI examiners. Next slide.
So I think when we first came, when we talked about the FSDR framework, we thought we were going to be doing sampling. And I think this slide is probably a surprise for many of you. We made a determination that sampling was unnecessary because of the low numbers of cases in which FBI examiners did testify You see they sort of range from a high of 132 in latent prints to really a low of 17 in paints and polymers, and sort of range across there. So, I think whenever you're given an option with reasonable numbers of cases to look at a whole population, it makes sense to try to look at that whole population. I want to note, so this information was provided by FBI, but we also really want to make sure that we're looking at the whole population, that we're not missing cases. So you see there where there's a crowdsourcing request. That's going to be forthcoming. Once we've established which discipline that we're going to start with, we're going to put the word out, and we will ask people to send us the names, the information about cases they know of where FBI examiners did testify, so we can reconcile our lists and try to make sure that we have the actual population of cases.
Perhaps the key question in review of testimony is the level of that review. Such a review can range from looking at individual statements and evaluating them without any broader context to looking at the entire testimony and attempting to determine if the testimony as a whole was problematic. The FSDR, informed by the academic literature on how testimony on pattern evidence is perceived by triers of fact, proposes to adopt a methodology that is a hybrid of these two approaches. We propose to break a given testimony into what we're calling threads, which are defined on the screen as complete, even if not continuous, discussion of a piece or pieces of evidence that has at least one statement of relationship.
And you have an example, I think, in front of you. We'll also look at it on the screen. One thing I just want to note about this attempt to threads, and we're really interested to hear what you have to say about this, and we're interested in your feedback. I think the threading is really an attempt to try to get at what testimony in a courtroom actually winds up being like, where you might talk about one piece of evidence early on in direct, and then it gets picked up later in the direct, and then it's talked about on cross. It's an attempt to sort of group all of those together in a single thread so that we can look at that as one continuous item.
So what we're doing with threading is, as Kira indicated, we're trying to preserve the relevant context while excluding irrelevant information to that piece of testimony. Relative to evaluating the whole testimony, which may be appropriate given a different goal, if that goal, for example, is to determine how consequential that testimony was in determining the guilt or innocence of the defendant, threading requires less judgment on the part of the evaluator and preserves the focus on the examiner's statement, which is again consistent with the goal of the forensic science discipline review. All right. You should all have handouts in front of you in case you don't want to squint at the screen. If you want to squint at the screen, feel free to do so. The handout you have helps just give a very basic illustration of what we conceive of by threading. The first block of text, which is highlighted in green, refers to 32 casings. And there is no statement of relationship in the green block of text. However, if the testimony had never broken down those 32 casings and there was a statement of relationship, we would call that one thread. But what you'll see as soon as you get to the yellow highlighted text is that the prosecutor breaks 21 of the 32 casings out and will, in the balance of the testimony, only talk about those 21 casings as a group. In what's highlighted on the screen, there are two statements of relationship. One where the prosecutor asks the examiner a question and the examiner answers by saying that's correct, but then the examiner goes on to make an independent statement of what we call a statement of relationship. We can continue the same example. The second thread, highlighted in blue, is about 9 of the remaining 11 casings. There are 3 statements of relationship in this thread. The final thread with 2 statements of relationship refers to an additional 2 casings that the examiner, in this case, could not say if they were fired from the known weapon and could not even determine if they had been fired. The idea behind threading would then be to collect and thread all subsequent mentions of these three groups of casings across direct examination, cross-examination, redirect, and recross, and so on throughout the examiner's testimony, and to aggregate those into a thread for analysis by coders. All right. Oh, wow. We're only missing one screen, so.
Yeah.
Okay. The final major component of the proposed FSDR methodology is how to actually conduct the review. We essentially propose an academic research model to develop a validated protocol to code the statements of relationship and then train coders to apply that protocol to the threads that we identify. We plan to ensure consistency by assigning the same thread to multiple coders and collecting data on inter-rater reliability. We can also use these data to assess the accuracy of our trained coders. We also plan to pilot in order to refine a protocol, so we'll identify a set of cases that occur outside of the FSDR frame, and we'll use those to develop the validated protocol and to train the coders who we would have do the task of evaluating the testimony. As we've mentioned, we will be posting a research proposal later this week for public comment. We're interested in the views of the commissioners and other stakeholders generally, but we wanted to mention a few items on which we are specifically seeking comment. First, we believe that statements of relationship can be coded on where in the testimony they occurred. So did they occur on direct, did they occur on cross, and so on. Who spoke the words that were the statement of relationship, what those words were, the type of relationship, again, association, inconclusive, exclusion, and whether the statement was subsequently bolstered and whether the statement was subsequently qualified.
And we're, of course, interested to see if there are other aspects of statements of relationship that could be evaluated. One thing that I want to note is about who spoke the words that were affirmed by the examiner. So in order for a statement to become a statement of relationship, it does have to be affirmed by the examiner. But I think we know often that question or statement can be made by a prosecutor or defense attorney, by the court, and then simply, yes, that's correct, might be the affirmation from the examiner. And we're interested in looking at those as well as just the language that came out of the examiner's mouth.
We've kind of conceived of this notion of statements of relationship and threads and testimony, and we hope to tap the expertise that's available to us to help us determine how best to understand and report the data that we collect. We know that threads will vary in the number of statements of relationship they contain. We know that testimonies will vary in the number of threads that they contain. We know that as we adopt these FSDR standards, they may, from discipline to discipline, identify statements that are acceptable in some disciplines that are not acceptable in other disciplines. These factors require that we account for them as we aggregate and analyze the data. Our intuition, our belief, is that the best approach is to conduct exploratory data analysis once we have the data, but we're interested to see if there's a statistical model well suited to these issues that we can use as a starting point.
So, I think, again, one of the things that we talked about in March was that we thought we were going to be looking at a sample. And so we thought there would be a sample and potentially a secondary review depending on what was shown in that sample. Because we're looking at a full population of cases, the utility of sort of a secondary review following a review of population doesn't make as much sense. It's not really clear exactly what that would look like. That said, there could be outcomes that we see as we observe the data where it's appropriate for the department to consider looking at other cases or other sets of cases. And we've listed a couple there. We're also interested in what you have to say about what some of those examples might be. Again, some of them might be that testimony earlier in the time frame has less conformity with the standard, perhaps a particular discipline, or perhaps we find that a particular examiner will obviously have that variable and be able to determine fidelity with, or conformity rather, with the standard across examiners.
We also recognize that when we find nonconformities, that it may trigger legal or ethical obligations for us to notify defendants. And we're very much interested in comment from the Commission and from the public about what is the threshold that needs to be met before some type of nonconforming statement that may exist in a variety of different threads triggers any of these legal or ethical obligations. And specifically also we're curious as to your thoughts about if we use as part of our FSDR standard something that's different from the uniform language because the science has been changing or the information available to our experts has been changing, whether there's any sort of difference that may occur in terms of, again, our legal and ethical obligations in terms of notification. So with that, let me just remind you, so there's comment on the uniform language in the 7 disciplines that have been published. That's open through July 8th. We anticipate over the course of the next weeks or month or so additional uniform language documents to be posted, and we anticipate that comment period to run into July and probably into August. The comment on the FSDR draft methodology, again, that's going to open shortly as soon as we publish that on the website, and that will run for a period of 30 to 45 days. So again, back to our process. We introduced the framework back in March. We've been working on the methodology over the course of the last several months. We have presented the draft methodology to you in this presentation. We'll be publishing the full text of the draft methodology in the next week or so. We'll be holding the statistician roundtable next month, and we intend to present what we hope is a final revised methodology to this commission for your comment, for your review, consultation, and comment. And then once we have the methodology finalized, as well as a standard by which we're going to compare and review the testimony, we hope to begin FSDR implementation. You should know that in parallel, obviously we have the ULTR process going in parallel with the methodology. At the same time, we're also putting together a budget and trying to find the money to do this. This is going to take millions of dollars. It's probably going to take at least a year and probably longer. And so we're doing that also in parallel. And so with that, I think we'll take any comments, any questions that we'll try to answer any questions that you might have. And I think we can go for a half an hour or so. Anyway, we're happy to be here and answer any comments and hear any answer any questions and hear any comments that you have.
I think we knew who our first question would be from. Please.
I'd like to begin with some comments, and then I actually do have some questions. So in the initial filing in the Federal Register, several of us submitted a joint set of comments. And it had 3 components. And I just want to read a couple of sentences from that because it's a precursor to my observations regarding the presentation today. And we began by saying that we believe that the design and implementation of the proposed review should be done by an organization or group that is independent of the Department of Justice. That is not happening. And we went on to explain why an arm's length evaluation, independent in arm's length, was so essential, both for transparency and for public trust in the outcome of the review, and that these could be assured only by an independent process. We outlined some of the statistical issues that would be associated with creating a methodology, and we noted that the expertise to do the design that we outlined and to carry out the review does not exist within the Department of Justice. Everything I've heard today suggests that our advice is being ignored. And I want to point out that each of the steps, while laudatory in some sense, is moving the entire review down a pathway that ultimately is going to leave it open to major challenges. So the choice of methodology affects the outcome of what's going to be reported. Uniform language coming from the FBI lab is terrific because it gets the FBI lab actually thinking about what it should be, its analysts should be saying. But are those the standards by which any independent review should actually be carried out? I would argue no. And if you look in detail at some of the statements, I would argue that they are not scientific statements. Selection of cases. The time frame is an essential component of that. The presentation said you have a rationale for that, but it's the Department of Justice's rationale and not an independent one. Are 132 latent print testimonies appropriate for evaluation in the large of what's gone on? I don't know, because it requires looking at the entire database and asking a relevant set of questions. Is the threading the appropriate data set to look at? I would argue hardly not. It's the tip of an iceberg. But what are the real data that undergird the statements in the testimony? Will they be on the table? Are we looking at this backwards? So I think that there are many questions, and I believe that the process that your group is going through is not in the best interests either of DOJ or of the FBI laboratories in the long run, and that there's a great need to step back and to assure that an independent group is actually looking at this and judging the relevance of the statement. What does association mean? You've presented that as if there's common language both around this table and within the FBI lab and in any other lab around the country with regard to how that relates to the evidence that the examiner is describing. I'm not sure that we have such agreement. Indeed, I suspect if we went around this table, there would be 33 different statements about what association means. I'm a statistician and I can tell you what it means to me.
So Dr. Feinberg, I'd like to just respond a little bit. First, I just want to assure you that the comments that you submitted on behalf of CSAFE with your colleagues from CSAFE are not in any way being ignored. Your comments and the comment period ran through the middle of last month. We have taken your comments, and there are a variety of aspects, including the independence and whether this should be done independently of the Justice Department, will all be reviewed, will all be considered, and there will be some decisions made within the Justice Department that will be presented here at the September meeting. You mentioned a whole number of different aspects of the methodology. And if you read the other comments, you'll know that we heard very many different conflicting views on aspects of the methodology. And nothing that we've presented here today suggests that these are sort of firmly decided by the Justice Department. They are draft elements of the methodology that we very much want your comments. And so when you talk about, for example, do we have the time frame right? We're not sure we have the time frame exactly right, and we hope that you and the other members of the commission and the members of the public will tell us what you think the appropriate time frame is, and why you think that time frame is the appropriate one. We have suggested, Kevin laid out for you, the way we look at this using an academic model, and that we're talking about using professional coders. Now, we know that we've heard already, again, as part of the comments from the framework that we presented, many, many different views about who should be involved in it. And as you know, in the New York review and in the Texas review and in the FBI microscopic hair review, there were not independent coders. There were members of the defense bar. There were lab technicians, FBI lab technicians who were involved. In some of them, there were prosecutors involved. So we're not suggesting that we know in absolute terms that we have it right. We are laying out a draft, whether it's on time frame or the standards to be used, the types of coders, and all the various aspects of the methodology. We're laying out as a draft for people to submit comments. So we want those comments. They will be reviewed. There will be discussions both within the Justice Department and outside the Justice Department about how this should be conducted and all the aspects about how it should be conducted, starting with whether it should just be done by an outside group, as you've suggested. If it's not done by an outside group, who should be involved in the coding? Should we be using threads or should we be using individual statements? Should we be using the uniform language or some different language as the standards by which to compare the testimony? There are innumerable questions, and as I said in the beginning of my presentation, the comments from the framework give us a preview or a view into all the different views and the conflicting views that I'm sure, will hear from around this table about who should be doing the review and how it should be done in the various aspects of the methodology. So what we are presenting to you today is a draft. And the questions that you raise are important questions, but what we're looking for, to be perfectly frank, what we're looking for in your comments are your suggested answers. We know that there's no certainty about 2008 to 2012. We know there's no certainty about this threading. We know, because we've looked at the literature, when we've looked at the past experience. We want statisticians to be involved. We're suggesting the roundtable. Maybe that's wrong. Maybe there are other ways that statisticians should be involved that we don't have right. Please let us know. Let us know here right now. Let us know in the written comments. We will then be looking at all of those written comments. Yes, we will be consulting internally. This is a Department of Justice project that we want to have the trust and confidence of this commission and, frankly, of the public. And so that's why we're presenting it to you in March, in June, in September. Hopefully we can find a way forward that this commission can support. That's our intent. We don't intend to, we're not intending to tell you this is the way we're going to do it, take it or leave it. We're looking for comments on all the various elements of the methodology.
And if I could just add, Stephen, in terms of the standards, I think you mentioned at the tail end of your comments whether the LTRs is the right standard and whether those words that are currently written in them would be used. And I think what we're trying to make clear here is that we don't perceive it as being the standard for the FSDR. And in fact, we're very cognizant of making sure that the uniform language was put out before, so we would have the benefit of this body and the public and understanding, what those right words and associations should be, and that could be used to inform the FSDR standard, which we really, truly believe probably will be slightly different or very much more different. And you would have the opportunity again here, once we have one that we think the community has consensus around, to look at and is this appropriate for the FSDR? They're proceeding in parallel. We consider them very separate, but we are trying to use them to inform each other.
Thanks. I think we have questions from Jim Gates and then Peter.
Thank you. And thank you. First of all, I'd like to thank the briefers for the on the panelists for a very informative set of statements. My question is actually sort of in the weeds, but something I would propose for you to think about. These sorts of exercises are likely, in my opinion, to be something to continue into the future. And if that's the case, not only is the direct product that you have in your foreground important, but there's something else that I think is really critical to this, namely that you set a template for something that could be used broadly in the future, which requires that you document what you're doing extraordinarily well. And one thing that occurred to me is I'm totally in the dark about where is information technology being used in this? Because one could imagine that if you document things well enough, part of this scaling up, because I would expect it to be needed to be scaled. I heard my colleague here asking about where you're going to get all the time for doing this, and that's certainly the right question. Taking advantages of computer technology, artificial intelligence, seems to be one way to leverage that creation of extra time. And so I hope and would encourage this group to keep us informed about the outer realms of what you're doing in terms of technology, in terms of the product, beyond the actual outcome, something that then becomes a tool that the department could use in the future to delve into more broad cases. So if you could respond to that, we'd like to hear.
Yeah, I think that, first of all, the comment's very, very helpful, and thank you for it. You should know that we received from comments on the framework a number of suggestions about institutionalizing this process so that it's not a one-off, but it's something that will continue within the Justice Department and perhaps be extended beyond testimony. I know there were comments back in March about extending this to reports, to statements of counsel. You could go to jury instructions. You could do all kinds of things in terms of review. One of the things in terms of putting together our budget is to make sure that we have the money so that we have the information technology systems. First, just to keep track of everything, as you said, it's record keeping. It's making sure that this, because frankly, whoever does this, whether it's the Justice Department or an independent agency, an independent group that's going to be doing this, it is going to be scrutinized and it is going to be looked at potentially to be used going forward. We're still, it seems to me, having read through our own literature review, that there is no certainty about exactly how to do this. So yes, we're thinking about it. We have to find the money to make sure that we have the information technology, and then to be able to use various technologies to be able to do this in a more efficient and effective way going forward. So yes, we're thinking about that.
And I'm sorry.
I'm sorry, may I also, partnering outside of the department is going to be absolutely critical. So at some point, we on the commission, at least I know I personally, would like to know who your partners are in this process.
A couple of points. Obviously, we benefit from a close relationship with NIST. Obviously, we have some in-house expertise within the department. One of the things that we think about as we kind of embarked on this is there's an opportunity here for something like natural language processing or something like that. That requires a lot more data than we're looking at right now. But that doesn't mean that as these data sets don't build, that you can train something to kind of look into the future and take advantage of enhancements in technology in processing power as you kind of move forward. And we'll attempt to be cognizant of that.
Is that on? You're on. I'm on? Okay, thanks. Good morning. Just 2 points I wanted to make. One is a point of clarification, and the second one is a question. The clarification is only because this is a public meeting, and so what's said is sort of thought to be have biblical significance. You commented that you were trying to compare what you wanted to do here with what the Texas Commission did and what the New York Commission did. So just to set the record straight, and as much as I'd like the legend to be printed, not the fact is there is no New York hair review at all. In fact, notwithstanding the fact that 8 other states have embarked on a state hair review, and notwithstanding the fact that the director of the FBI recently wrote letters to all those governors, including New York's last week, urging them to conduct a hair review, that the New York Commission, frankly, wussed out, simply thought that they lacked the capacity to do this kind of review, and so they didn't do it. It's very, very disappointing. It's actually typical. As much as I'd like to defend my home state, we have many more reforms being implemented around the country and other places on ID. The federal government has done great things recently on recording interrogations. New York, unlike 23 other states, declined the opportunity to mandate recording, and so with the hair review, they've also decided to pass. But you can look at other states besides Texas. Virginia's doing one, North Carolina's doing one, Massachusetts announced they intend to do one, Iowa, the governor announced that they're going to be doing one, and we probably expect that after the recent letter from the director of the FBI, that more states will be joining the ranks of state reviews. Now, the other question, though, is more directed at something that you said this morning, because it raises a very serious question. You said that the actual test that you will utilize to analyze testimony will be whether or not it was consistent with scientific principles and whether it was consistent with just outcomes. Now, I guess I could understand, at least in the abstract, how you evaluate whether something is consistent with scientific principles, but I don't know how you are going to evaluate it in terms of just outcomes. One of the concerns that's been repeatedly articulated in this commission is, for instance, in the pattern and impression disciplines, that it's not enough to simply say that something creates a positive association or that something could have come from a defendant based on our analysis, that it's incumbent on the examiner to affirmatively state what the limitations are of that discipline, how much uncertainty there is, what's the error rate, and all those kinds of limiting statements so as not to mislead the fact finder. Very, very critical. And that it be done proactively by the expert who's testifying. So, whereas you might look at a statement and say, well, all he said was it could have come from the defendant. He didn't say it did. He didn't say it's to the exclusion of the rest of the world. He only said that. But if you don't affirmatively add limiting language, if you don't affirmatively put out the disclaimer, if you don't affirmatively express uncertainty or error, then you will be misleading the fact finder, or at least there's a great danger of misleading the fact finder, and you will not have a just outcome. You won't. And so it's very, very important when you think about whatever methodology you intend to use, that it's not good enough if somebody says something that is simply on its face not untrue. If, in effect, it will still have the consequence of misleading the fact finder. Because the one thing that we have found at the Innocence Project, when we looked at approximately 50% of the wrongful convictions where the misapplication of forensic science played a role in the initial wrongful conviction, was, generally speaking, it was the failure of the analyst to place limitations on his conclusions, to express uncertainty, to express and communicate error rates. It's all those failures which lead the fact finder to exaggerate the probative value of the evidence that was given. It's not necessarily that the underlying bench science was fundamentally flawed, it's that the way the person chose to communicate it was a partial picture but not the whole picture. So you have to think about a way that you're going to have language that not only is consistent with certain scientific principles, it should be consistent with all those principles, but also be communicated in a way that's not misleading and will generate a just outcome.
So Peter, thank you so much for that comment. Obviously, it's going to be absolutely critical, or it's going to be a critical part of the methodology. What are we comparing the testimony to? And I think that's what you're talking about and what it goes to. So, you know, we're looking forward to your comment and for other folks' comments, obviously on the ULTRs that are out there, which lay out the standards for testimony as well as some of the aspects that you talked about just now.
Thanks. I think we'll start with Dean and then work our way around the table.
Good morning. First, I wanted to thank you all very much for the presentation this morning. I actually wanted to offer a compliment to what you put together because I can only imagine the amount of detail and opinions and thoughts that you had from so many people to structure something. And I think what you have is a great start. So I don't want that lost in the discussion, at least from my perspective this morning. I know there's been some excellent questions. I know Stephen's brought up some, significant concerns that do need to be addressed, and I think it can. But the point I really wanted to stress today, and it seems to be buried, is I think working through the methodology will be fine. I think you'll find an outcome, and whether this is phase one of many phases or additional work, whether it's the complete work, as perhaps what Stephen is suggesting is being done, I'll leave to you to decide. My concern is about, and you mentioned very briefly, the legal obligation, because I really think the ultimate impact of this entire review is going to hinge on what happens after you have your results. That, to me, is the most significant issue that's going to come about in this project, and I think that's the area where I'd like to see, for myself, the biggest focus and attention to make sure that we're doing a very complete work in this review. And I'll leave it just very briefly by saying, there's concern, question, and even a review about exaggerated opinion. I just want to make sure that we don't exaggerate the impact by being premature about releasing information. I think as you go through this project, you need to make sure that before the impacts are delivered, spoken, issued, that you've thoroughly vetted what those are, because I think the impact to the field of forensic science, to the criminal justice community, and ultimately those that we're protecting, whether holding those accountable or exonerating those who are innocent, those are the ones who are going to suffer the most, have the greatest impact if that's the case. So I just want to make sure that that's not lost in the discussion of reaching about, do we do X or Y, when ultimately we need to consider the downstream impact. Thank you.
Yes, well, as I mentioned at the end of the presentation, we're very much thinking about the downstream decisions that have to be made, and again, we're looking for comment on that. And I just hope you're right that getting through the methodology will be no problem at all. So.
Thank you. I really do appreciate that what you're doing is extraordinary on the one hand, and gosh, why wouldn't we do it on the other? I realize it's extraordinary in this environment, and so I thank you for that, but gosh, why wouldn't we? And why wouldn't we always be doing this, and why didn't we do it sooner? So I also am concerned about this, I appreciate the idea of transparency is to invite all comments. But in the end, I get lots of opinions about what my house should look like that I'm building, but I get a contractor to build it. I think that I worry that in this process, you are not going to the experts. Why not go own it? Go to the experts. That's who you're going to ask to do it, and I agree, those experts should be independent of the Department of Justice. And part of the reason I think it's important that you do that is at some point you also need to pay these people to do this. There's a lot of relying on the goodwill of people that have day jobs, other research, other experience, other reasons to be focusing their research somewhere else, to pay attention to this issue. And it's amazing that they do as much as they do, but in the end, it's not theirs, and you're just bringing them in, and it's exhausting, right? At some level, I think it replicates this commission. We all have day jobs. We do what we can here, we contribute as much as we can, but we're not staffed for this. And I think you need to think about hiring the experts and letting the experts be sufficiently staffed to do the work. I don't know quite what we're going to do with this, I wish the screen was still up there, this just outcome and scientific accuracy, I think was what the two were. I mean, we're really stuck until you come up with a language. I mean, again, I agree with Steve. The language I've looked at for some of these standards is so vague and so without rigor. It's sufficient this, sufficient that. One, I don't think that's scientific. So I think you've got two questions to ask yourself. Are we really trying to find out whether or not people testified accurately as a matter of science, in which case much research needs to be done to get to that? Or are we just trying to figure out if they followed the rules that were in place or that are now in place? And those are very different questions. And I think you have to be honest about which question you're asking. Are you really asking for scientific rigor? And with the standards that I see here from so many of them, I don't think so. Or are you asking if they're following the rules? And to the extent that they're following the rules, when I look at some of these, the uniform language here, I think, how are you going to define the rule? May do X if sufficient Y is what is in so many of these standards. I mean, what does it mean to violate that? And I also think it's not just outcomes that are impacted by the whole context of it. Even if, for example, the analyst follows all of the rules, it's how it's argued not only impacts the just outcome, but it impacts the science. What was the ultimate overall presentation of the science to the jury? Was it accurately presented? And part of that presentation is how people argue it. So I don't know that you're going to be able to evaluate either question, really, science or the outcome, if you don't look at how it's argued. Anyhow, I look forward to seeing more details and more opportunities to comment. I do think this is terribly important, but including the noise you may ultimately hear from lawyers, at some point you've got to screen that out and start listening to the experts and bring the experts in a way that keeps them engaged throughout.
Right, so Julie, if I could just react to just a couple of things that you said. First of all, on the experts, we are reaching out to the experts as best we possibly can, whether, again, that's from NIST or CSAFE or others. And as I say, we will tee up for others within the Justice Department whether this should be, sent out completely to somebody else. Of course, it will only be sent out to somebody else. It won't be presented to lots and lots of other somebody else's, and those people will also make decisions. There are difficult, and which gets me to the second point, which is there are difficult decisions to be made. And ultimately, at bottom, it seems that we're struggling, and we talked about this, Jules, I know, mentioned it back in March, the difference between validation of the science and understanding the presentations that are going on in courtrooms now and have been going on for years. And there's a distinction there. And we're trying to keep those things separate to some extent and also focus on, at least initially, are the presentations being done in a way that is consistent with whatever science we know, given the limitations on the validation, as well as leading to just outcomes. Those are difficult questions, and you point out the things that we're struggling with and we're asking you to struggle with, which is, okay, there are words on the page. That's why we put the transcripts up there in the presentation when we sent them to you. Ultimately, this comes down to comparing words on a page to something that we're calling a standard. That's just a difficult thing. What should be the standard? Peter mentioned some things that he would like to be in the standard. You mentioned some things, others. But ultimately, that's what we're being asked to do. And we're struggling with how to do that, whether to look at it line by line, threading, what is the standard we're comparing it to. So we encourage you, again, struggle with that with us and present what you think we should be doing, what we should be making, what comparison we should be making. We've presented some initial ideas for you to react to, but that's ultimately what we're asking from you and the rest of the commission.
I totally agree that this is incredibly important, and thank you for asking our advice. Mine is short and to the point. I strongly support what Dr. Feinberg says. Basically, independent review at some level. And there has to be a lot of effort into designing a rigorous study from the beginning, potentially vetting it through outside people. That is, do you want linguists in here? This is the level of that you want to look at this.
But it seems to me that, and to echo the words of Dr. Feinberg, this study will produce information that will be used and consumed by the DOJ. Is it in the long-term interest that this be done within the department, or will be done with an entity that is recognized to have outside autonomy? And I leave you with just one thought experiment. In science, we do a lot of thought experiments. Would the National Academy report on forensic science have had the impact that it did had it come from inside the DOJ who said the same thing? Would this committee exist? And thank you.
Phil's up too, but-
Yeah, we'll go to Judge Hervey and then come back to Phil.
So once again, I'd like to also compliment you for what you're doing. I think you're probably going to suffer from the no good deed goes unpunished syndrome, getting that feeling for some reason sitting here. But I have a question, might have been covered. I'm not sure it was. I think it's similar to what Julia said, and that is having testified, both obviously direct and cross, in a grand jury, and trial, and EBTs, your testimony is bounded by the question. And so analysts are sitting there, and you're looking at what they said, and you're looking at the question. Obviously, you're looking at a transcript, which can be significantly different from what actually goes on in a courtroom. And I'm hoping that some standards come out, standards probably the wrong word, some guidance comes out on how to, have it direct and across. And if it's adversarial, it's a whole different ballgame. So I'm just a little concerned that kind of the analyst is the sole focus of this, and that the attorneys who are participants in some instances in drawing out information that may be misleading or may be inaccurate, that they too bear the burden, or the court, the judge. The focus is on them also, not just on the analyst. It seems like the analyst is always bearing the burden. I may be a little sensitive in that regard, but I'm just hoping that that doesn't happen in this study. And once again, great work in moving forward with what you're doing, and the criticism that you're going to face, notwithstanding the great work you're doing.
Please.
Thank you. And what you point out is one of the things that we've noticed kind of looking through testimony is it matters who asks the question and how the question is asked, and then how the question is answered. And our belief is that that's something that we need to collect the data on, and before drawing conclusions on how to move forward, analyze that data, and then kind of move forward from there. Again, we're open for comment, and we want to stress that we value as much as possible the comments that we get as we develop this methodology.
Because I think what you're talking about is a really, really interesting question, a really important question. It may be that we are finding more instances where statements that are not consistent with a standard come from prosecutors or defense counsel or from the judge trying to rephrase something that the examiner had said. That informs training for examiners, that informs training for defense counsel and for legal practitioners. This is all super, super important information. So we are hopeful that this approach enables us to get at some of that, and we look forward to hearing more comment.
And that underlies, of course, the idea of threading and of coding, where did this particular non-conforming statement come from, and all of the different aspects of the way we're trying to collect the data from all of this.
Yeah, I was going to say, see, Phil, we think the same way. Yeah, I was going to comment on some of the things that Peter said, because if we can't just put this on the scientist, if the lawyers don't do their job and following up and asking about the stats or asking about nonconformities, then, part of it's on them as well. But I also wanted to make a comment, or I have a question rather. Everybody's talking about money, and obviously this project would be expensive. And to do it to the extent that we should for transparency and as many disciplines as we can, I'm kind of curious why you would include in your review cases that had no convictions. Because, that would cut down on the cost. I assume you've got the chart. I've got to brag. The Texas Forensic Science Commission is doing a great job with their hair review. They've done a great job with the DNA situation we've got. They do a great job on everything, in my opinion. But that seems to be something that I'm curious about, why you would look at those if there's a money issue.
Thank you for your comment. We appreciate it. I think because what we are really trying to do here is evaluate the testimony of the examiners, we are not focused on the outcomes. It's quite different than the way the hair reviews were coming at it. We already knew there were some issues there, and we haven't identified issues with these particular disciplines, and we really want to focus on how the examiners are testifying, and so that gives us some leeway to be able to look at a broader range of cases. And I think, as you see from the numbers, because they aren't as astronomical as I think we thought they would be, it gives us a little bit more comfort that it's not going to take that much more work.
Jules?
There we go. Good morning and thanks. I'd like to go, if this is the right time, to the original published proposed uniform language standards and really ask a question about them. I mean, I had the privilege of making some comments already, but the question I have is, in reading them, who wrote them? And I'm referencing in particular the suggested language for forensic examination of footwear and tire impression evidence. And it says, for example, a person may state his or her opinion that the shoe or tire is the source of the impression. And it goes on and says it requires that the two, the known and the question one, correspond in class characteristics and also share one or more randomly acquired characteristics. And I couldn't figure out if there's any science behind that whatsoever, and I just wanted to know who wrote it. Was this done by scientists? Was this done by lawyers? Was this done by practitioners? And as we say, I'll take my comments off the air.
So these documents, as I think we indicated in the Federal Register notice, are based on the FBI ASTERs, which were primarily drafted by FBI laboratory staff. They were turned into uniform language documents through a collaborative process with participation from other department analysts and laboratory scientists. And you raise a really interesting question, and we look forward to seeing it in the comment period. So I think we had, so if there are no other original, we'll come back. If there are no other people who haven't yet spoken, we'll go to Peter and then Julia.
Yes, Judge Hervey, I had hoped that after I complimented Texas and disparaged my home state, that I wouldn't get any pushback on my comment about where the issue lies in the courtroom, but so be it. Texas does deserve to be complimented on its work and its commission's work, and New York does deserve the criticism. But moving on, although I agree with you that training of lawyers is extremely important to do their job, one of the things that is unquestionably at the center of wrongful convictions over the last 30 years is the realization that we need upstream fixes. That the reason that an expert witness is allowed to give his or her opinions is because a judge has determined that the subject matter is beyond the ken of jurors. And it's often not just beyond the ken of jurors, it's beyond the ken of lawyers. Because lawyers are lay people just like jurors. And they may not have done their homework. They may not fully understand it. And so we have decided to place more responsibility, if you will, on the experts themselves, because they should know better. And that's why we say it's not enough to say something that is technically correct if it's very clear, or it should be clear, that you will mislead the fact finder. There was a case tried last week in New York State. John Butler, you might be interested in the case, because the DNA analyst tried to do DNA testing, did DNA testing, but got no results. Simply got no results. There wasn't enough material there and got no results. The prosecutor then asked the analyst on examination, so it would be fair to say that you couldn't exclude the defendant. Now, obviously, if the analyst responded, that's correct, that might be technically true, but there's no question it's misleading. No question at all. And there's also no question that that's an inappropriate answer. And there's no question that even if a defense lawyer is too stupid to object to it and explain why it's inappropriate, it's still wrong for the analyst to give that kind of answer. The analyst has an affirmative duty that if somebody asks an inappropriate question like that, because he or she knows the science, not the lawyer, to set it straight. And that's why I'm saying there's an affirmative obligation to put in that limiting language. There's an affirmative obligation at every bend in the road to include the expressions about uncertainty or for instance, hair. It wouldn't be enough to say that, saying that the hair could have come from John is not like saying it's to the exclusion of the rest of the planet, unless you also say all it means is that he's a member of a pool of people the size of which is unknown. Because unless you affirmatively add that other language, you will mislead the fact finder. And we can't simply say that, well, it's up to the lawyer to do that. And Phil, when you say, the problem is the question, I disagree with that. That's always been the approach in forensic science that, hey, my hands are tied. The lawyer just asked me this very narrow question, and so I had to answer it. That should not be the principle that we want to be part of this culture going forward. The principle that we want to be at the center of this culture going forward is that you, as an expert with special scientific knowledge, intend to give that to the jury completely with appropriate limitations and not simply be bound by the question.
So in response, I just said it was part of the overall picture, not the picture. And I don't know the context in which, in the case that Peter just cited, the question was asked. I don't know what the experiences of the analyst was the first time they testified. I don't know if they were prepped to say that or just boom came at them and they're kind of like a deer in the headlights. So I don't know what happened in that particular case. And I think it illustrates my point even more that as you look at the transcripts, you don't know whether this was a deer in the headlights case, and it's part of the mix, not the sole component of the mix.
Great, thank you. It looks like Julia, then back to Judge Hervey, and then Dean.
Thanks. I just wanted to quickly, I think the summary of all this conversations is not just looking at the associations, but you're going to have to look at the dialogue about limitations. Or, I'm sorry, the summary of this is whatever happens here, you're going to have to start looking at how do we deal with the testimony about limitations. When it's present, how is it handled? What are the answers? And I realize, I think I forgot to mention, you talked about the threshold for notifying defendants. Those are very small numbers you have up there. Don't delay. Get it done. Get it out to them. If you want to, not scare the whole world when you do it, I'm sure you can think of creative ways to do it, but especially if there's somebody sitting in jail, get it out there, get it to them quickly, their lawyer, them, the institutional public defender, make sure somebody's paying attention so we don't have a repeat of past mistakes of reports that sat in drawers for too long. Thank you.
Peter, I don't disagree that scientists should give complete answers, but I do believe part of the reports that the Innocence Project has put out as causes for wrongful convictions has to do with ineffective assistance counsel. And so I'm just saying that you've got to educate the lawyers as well. And you have situations where we have judges that don't know what they're doing as well. We're lawyers, but we have situations in Texas. I can think of one case in particular where a scientist wanted to give a complete answer and the judge shut that person down. So it is important, what you say is important, but it's also important that the lawyers understand and the judges as well. And so I'm just talking about a complete picture. We just, we can't just beat the scientists up and say you have to come forward with everything you know and not have the lawyers understand what they're doing in court. So,
Thanks. And I think we have a question from Dean, and this is going to be the last question. Not my choosing, just so we're clear. We could sit up here all day, but we do have to get out to the rest of the stuff on the agenda.
Well, I'm honored I get the last word, so thank you. I just really wanted to continue that bit of discussion. Having been a practitioner for over 25 years, having testified in many cases, which today would be considered one of the subjective areas, particularly trace evidence, crime scenes that involve bloodstain patterns or shooting reconstructions of some kind. There's a lot of subjectivity that comes into that. And I can tell you in those cases, those specific disciplines, there tends to be a higher propensity of attorneys or judges in the courtroom creating blocks for us as forensic scientists to be able to testify the way we normally would. And so rather than debate the issue, I'd actually like to recommend, if you're not already going to pursue that as part of this study, is as you're looking at coding, look at the questions that lead to whether the examiner is prevented from presenting something, because I think that's a very valuable, useful piece of information that can help guide what we're really talking about here is criminal justice reform, not just forensic science reform. And so I think we really need to maybe capture that since you're already looking at transcripts and looking at those questions. I think that, to me, would be something valuable. So as a direct feedback point, that's my recommendation.
Great. Well, thank you all. And again, I urge you, look for the methodology. We'll send it to you. And please submit comments as part of this process so that everyone can see them and then so that we have the benefit of all of your expertise. Thank you all. We'll see you in a couple months. Have a wonderful summer.
Next, we're going to go to Jonathan McGrath, who will give the update on the SPO in terms of the revised bylaws and some of the other things that are happening there. Just a reminder for everybody to speak directly into the mic so that those who are doing the transcription can accurately capture that. So thank you.
All right. Good morning again. So we've got a really quick update from the Subcommittee on Procedures and Operations. We had about 3 conference calls since the last meeting and just had a few updates that we wanted to share with everybody. Let's see. How do we get this? There we go. Okay. So real quick, we're going to go through, and the information that we're about to cover in these slides is also included in the electronic binder at the front portion, in the first chapter or so. We've got one minor update to the bylaws that I believe we're going to vote on. We're going to review an extra comment that will be put into a views document note that already exists. And then we also discussed adding a note to the recommendations document to be consistent with the views document note as well. Each of these notes are going to be noted in the work product development process as footnotes to the existing language. And then Matt Riedel will be presenting on the reconciliation of the 2 medical legal death investigation documents on accreditation and certification. So the additional statement that the SPO discussed is added to Section 5 under Commission Work Products. And at the very end, the statement that's proposed is when work products are adopted by the commission, technical and conforming authority will be granted to commission staff. So we realized there was no ability to allow for commission staff to go through and edit typos, provide minor edits, add the additional notes to the work products and approval dates. So we wanted, the suggested language was to use this particular statement to grant technical and conforming authority. I believe this is standard language that is used in the legal community for this type of thing for bylaws purposes. So I'll open it up for questions because I think we would need to vote on this statement as an addition to the bylaws. Does anybody have any objections? Oh. Yes, Jim.
Not an objection, but a question, which is, you know, yes, many of us are used to having technical fixes of language as we write reports, but where's the feedback mechanism here so that someone assesses where a technical change crosses the line and making a substantial change?
That's a good point. I don't think that's something we thought of specifically. Do any SPO members or, yes, Arturo?
So one mechanism would be that, except for typos and things, the document goes back to the committee. I mean, if there is to say what Dr. Gates basically alluded to, because, you know, a word here and there could certainly change the meaning of a work product.
I think staff is very aware of changing or editing, removing, you know, periods, commas, semicolons is very important in specific situations. So I think if we run into an issue where we have any question, that we would go to the SPO or to the subcommittee members who wrote the document to confirm. And if there's something that does need to be brought back to the commission, I think as we'll see from Matt Riedel's presentation on the MDI documents, that's probably the way we would go about it. So I don't know if we need to put anything specific into this statement, but I think we've got a general mechanism for providing that review and feedback. Yes, Jules. Sorry.
Okay, I think that we should put something specific in. I think it could go back to the committee if they could do it quickly, or a very easy way to do it would have it go back to the SPO since we meet more regularly. And I think it should be everyone goes back, because you shouldn't be depending on someone else to determine whether or not there could be a meaning change. And I think that could be done very quickly and easily.
I just want to follow up. It's document done. That is, after a voting, if this will be changes after a vote is done, right?
Yes. Correct, yeah. After it's been adopted.
Correct. I don't know what to think about that.
The real simple echoing of Marilyn, it should be simply built into this that whenever that happens, so there is no debate or concern as to which are purely grammar and which might change. And I'm agnostic as to the SPO versus the particular subcommittee. It may be easiest to be the SPO, but there should be something.
Trying to decide if I actually have something to say. My recollection was that the SPO was charged with the responsibility for these types of review and revisions within the bylaws, and that this is really simply a formatting issue. So I think that there is already built into the bylaws ways to address the concerns that I'm hearing from Jim and Marilyn and Arturo as far as how we're doing this. So, I mean, I would like to go back and take a look at this, but I suspect that this is already language that's in there, and we may be talking about something that's already been accomplished, because we're having those discussions within this group as to how should this, what is a meaningful change, what isn't, and certainly with the recognition that this group as a whole could certainly object to any change that was being made. So I think Matt may have some more information along those lines, but I hesitate to say for sure because I am not looking right now, but I think this may have been addressed.
I'd like to echo what Pam said because that's exactly what I recall from the SPO is that, and to Arturo's point, the idea was we had 4 commissioners on the SPO to review and make sure that there was nothing being put in change-wise. Perhaps the word that may be causing some concern might be technical because it suggests that perhaps maybe there's something more overreaching in the change. So I think really what we're talking about is format and a little bit of grammar here and there. The addition of approval dates because they come as drafts. It was never meant to be changing language or changing anything of substance. And I think that's the job of the 4 commissioners on the SPO, that if that were to happen, that we would ask that that would come back and we're the balance to make sure that that doesn't happen. So to the extent that makes people a little more comfortable, that's the direction we were headed.
And to piggyback on the last 2 comments, what we're really talking about in a lot of instances is where it's a views document, that the view of the commission start out, it is the view of the commission that. We're also talking about that the view of the commission, for instance, in a views document, is stated before the background supplemental information is provided. It's that kind of formatting that we're referring to, I think, as technical type authority, and not to changing the gist or the meaning of a sentence or paragraph.
Yeah, under the SPO, number 5 of its tasks is to make non-substantive revisions to reconcile adopted commission work product documents. I mean, I think you might want to make a tweak there that it's to make them and to review any made by staff. So give them some review authority in there, and that should take care of that.
That sounds good. We can add that statement as well. Yeah, once we have technical and conforming authority. No, that works for me. And I think that captures the idea as well, so thank you. Do I have a vote on this? All right, I think we'll...
I think we need to make a change.
Oh, okay. Do you want to bring... Can you bring up the bylaws? Tomorrow?
Do we
Yeah, I think what we
move
heard-
to vote on the idea, move to vote on it with the idea that you will, by the next meeting, give us some proposed review language for the SBO?
We'll get these bylaws done before this commission ends, I promise you. No, I
It's a
agree.
living
I agree.
document,
We
Nelson.
just
It's
need to
all
get the
right.
language right, and we'll come back to you. But, because I think it's a minor tweak.
Yes, Ted? Yeah.
You may be getting to this. I just had a comment about the work product development process. Are you going to get there, or?
Yeah, we'll get there in the next couple slides.
Okay. Well, before we get to that, one thought. Every time we get these final drafts out, there's inevitably a typo or something that slips into these things. Is there no way that somebody within the Department of Justice can proofread these before we get them in final form? Because it's really not a good use of the SPO's time or anyone else's to go ahead and to try to do editorial revisions after the fact. And there's got to be somebody who can sit down, proofread it, get it to the subcommittee. They can make those minor changes ahead of putting these out for comment or even for final publication. So I mean, it just seems to be a simple fix to a recurring problem.
Yeah, and I think we can use some of the contract support and editorial services to do that. I think we would just ask that we work closely with the subcommittee co-chairs to figure out when the best point in the process is, because we want to make sure we provide everyone a sufficient amount of time to meet the deadlines to get all the votes in and everything else too. And I know there's a lot of minor tweaks that occur, even that are substantive before the subcommittee votes occur as well. So I think we're just trying to capture a good system to fit in the editorial proofreading process. So, but we have that available. So I guess I encourage the co-chairs of the subcommittees to reach out anytime that they would like a specific formal proofreading to occur at any point in the process. All right, so I'll move on to the views and recommendation notes that were discussed at the SPO. So we already currently have a note that's in the views template, but there was one comment that was suggested to be added, and this is based on, I believe, the commission discussions from the very beginning as to how the votes were occurring. Speaking generally, that the votes may be specifically for the general top high-level views or recommendations, but not necessarily every bullet or talking point or, within the document itself. So we added the statement, only the portion of the document directly labeled views of the commission represents the formal views of the commission. Information beyond that provided for the specific views of the commission should be considered supplemental. So, any issue with adding this additional statement to the views note? All right, and again, this is a...
May?
Yes, please.
So then what are those extra words? They're coming in a document that the commission has approved. One of the reasons we have used documents, if I understand it correctly, is we're sort of the, pardon me, Franklin Delano Roosevelt, the bully pulpit for all things forensic. But if we now publish something that says, listen, and we're also already confined to making the views part this very narrow statement, the history, the background, the thinking, which gets a lot of vetting here, is now, I don't know what. And so I'm concerned about this because it seems to strip the significance from a lot of important information, one person's view.
Jules, I see your point of view, and I think from the discussions that I recall on the SPO, it was by no means meant to be exclusive in any way or to create a de minimis of importance of the work and effort put into it or even the value that that has. I think we were just trying to make a distinction between perhaps something that was maybe more binding versus something that is more descriptive. And so the views were meant to be something that the commission believed that the Attorney General could not necessarily enforce, but it was a way for us as a commission to get a perspective out that could influence or create change within the community. And the language is important, but there's sometimes discussion in that language that would be up for debate or up for discussion, and it was meant to be that that isn't necessarily a commission stand as opposed to just providing information. I don't know if I've spoken that clearly enough, but that's the distinction we were trying to make.
Do we have Stephen?
I just want to reinforce Jules' statement. It seems to me that we spend an inordinate amount of time refining every word in a views document, and to then make a statement that it doesn't matter and that we didn't take all that time and effort seriously is inappropriate. I think the documents are what they are, and we have committed enormous amounts of energy and effort in framing them, and they exist the way they are and should be taken as a whole.
If I can just comment, I think if we think back, there was a lot of discussion on the the background or supplemental material that was placed in there, and a lot of commissioners expressed concern about what are we voting on. And I think we repeatedly said, listen, we're voting on this, this is background material. I don't think it diminishes anything, but I don't think we would have gotten those documents through if some of the commissioners who expressed concern about the supplemental language, they may have voted it down. So I don't want to now change history. I think this is consistent with what we've discussed on the floor here, that the only thing we were voting on was the actual view. And if we can change the language in this to make it clearer, that doesn't mean that the information is worthless. I don't think that's the point here. I think the point is that we always voted on that one thing. There was plenty of discussion on some of the other language which we couldn't come to agreement on, and oftentimes we would just say, here, let's just vote on this. So I think for consistency purposes, this statement gets there. If there's a way to improve it so that it doesn't appear that the information is not valuable, I don't read it that way. I don't think that was the intent of the SPO. It was simply just to be consistent with what we've said before. So.
Not sure who was next, but I'm going to go ahead and Judge Rakoff.
How do you turn this on? Yeah. So I can only talk about the reporting and testimony subcommittee, but the supplemental language actually played the opposite role in many of our reports. That is to say, it was a way of achieving consensus on the overall language because there were nuances that could only be expressed in the supplemental language that enabled people to reach a consensus. It's sort of like when in like courts of appeals, where you will often stick some language into the opinion that's not holding, but is necessary to get the votes of the other judges. And I think it may not have been the case in other reports. I'm trying to remember back, but I do think in at least the reports that came out of BATS and my subcommittee, the supplemental language was really critical to explaining in a more nuanced way just how far the views language went. So I worry a little bit about this proposal.
And Bill?
Hi, I'm here as proxy for Paul Gianelli, in case you're wondering. I think I agree with Jules and Steve and Judge Rakoff. I wonder about this distinction between a formal view and a supplemental view and what that means. Certainly, it seems like anytime there's legislation, it's a common issue that legislators have to decide whether to vote for a bill or not, even though there might be some portions of the bill that aren't preferred, and people generally vote for it as a whole, and it's understood that people who vote for something thinking on the whole it's good may not agree with every aspect of it. And so I don't really think it's necessary to say that. But I do think that saying that some of the statements in the views documents represent formal views and some represent supplemental views might raise questions about what those terms mean and what the force should be that are going to be more confusing than helpful. So I think my sense is that this is unnecessary language, that what it says is already understood. And if it goes beyond what's already understood, that it'll raise more difficulties than it solves.
Matt?
I think that the background information has been treated by us as being context. It gives context to the discussion and to the choices that we made. And I think it informs it in that way. For the lawyers on the commission, my suggestion is that this is similar to the advisory committee notes to various rules, that it provides some guidance, some context, perhaps an explanation of those sorts of decisions that were made. but at the end of the day, that what expresses and what the commission becomes more unified about is the actual statement of the views that we adopt. Otherwise, I would suggest that from time to time, there have been a number of things that have been proposed that if we had to agree with every statement that was contained within the document itself, we would have never gotten anywhere.
Hey, Julia, I think you had.
I agree with the sentiment so far, and I think we shouldn't include the language. I also think this isn't entirely a problem of our own making. I mean, two things. One, since the beginning, we have debated all of the language in all of the documents, and we've made changes as a compromise to comments made by commissioners. So there have been significant changes made in some of these documents in the background section over time. So it really was a part of deliberation. And I think I should just speak for me, thought we were doing it because we were really hoping these documents would be taken seriously, not just by the general community, but also by the Department of Justice. It was the Department of Justice who, after we had passed several of them, came in and said, this is how we're going to treat them. And so I don't want to take away from how much effort was put into this work. And I guess I'd include making that statement to the Department of Justice. I understand they've now been categorized as views documents and that they don't require action from the department, but that doesn't mean the department shouldn't be looking at them carefully because they were crafted at a time when we thought the department was going to be looking at them.
So I'd like to make, my first suggestion is dump the language. But if we don't, okay, I'm going to propose in my job as wordsmither, some wordsmithing here, which is you begin by taking out the word only and begin the portion of the document represents the formal views of the commission. You leave out only. The second sentence becomes information beyond that should be considered for context. It's real simple. It explains it. Again, I think we really don't need to say any of it, and it's going to complicate matters. So I'd really prefer a vote of don't have it. But if we're going to have something, it shouldn't be this wording. It should be simpler and less dismissive. So again, it would be information beyond that section or whatever is provided for context.
Well, I agree. Let's just take it back to SPO real quick, and based on this discussion, maybe we don't need the language. So I think it's creating more problems than it's trying to solve. So we'll go back to SPO based on what we've heard and discuss this again. I think that's the right thing to do.
All right, so I'll move on to the, let's see if we get there. The proposed note to recommendations document. So currently there is not a note associated with a recommendations document, and this particular statements, the statements that are on the screen, does include the very similar note. I'll read the whole thing and then we can discuss it as well. So the note is, this document includes recommendations developed and adopted by the National Commission on Forensic Science and proposes specific acts that the Attorney General could take to further the goals of the Commission. I believe this is the same language that is included in the Work Product Development Guidance and even the bylaws as well. And then the second statement, only the portion of the document directly labeled recommendations represents the recommendations of the Commission. Information beyond that provided for the specific recommendation should not be considered part of the formal recommendation adopted by the Commission. So I think we may have some discussion there as well. And then the final statement, this document does not necessarily represent the views of the Department of Justice or the National Institute of Standards and Technology. The National Commission on Forensic Science is a federal advisory committee established by the Department of Justice, and for more information, there's a link to the website. So any? Yes, Julie.
I think this is particularly suited to the edits that Jules just proposed. I think if you rewrite it that way, I think it makes more sense to me that this language is here, but I think I would rewrite it the way Jules proposed.
I agree. That's an excellent point. So, yeah, let's take it back. You done?
So the intention is to take the notes once they are discussed at the SPO, brought back to the commission and finalized. What we'll do is add 2 footnotes to the work product development guidance. You can see the 2 underlined descriptions for both recommendations and views. This is currently in the document for operational use on developing work products. So we'll add the footnotes just as an addition to that document. I'm going to turn over do you want to vote on the bylaws, or is that later on? Okay. I'll turn over the discussion to Matt, who's going to discuss the reconciliation proposal.
Excuse me, originally the here were adopted by the Commission at our 5th meeting. The document on certification of death investigators was originally adopted as a directive recommendation to the Attorney General, and the document on accreditation of medical legal death investigation offices was adopted as a policy recommendation. It was suggested at our last meeting that they be rewritten as views documents following the restructuring of our work products and given the limited authority of the Attorney General over death investigation. And go ahead. So what we have here are the changes that were in the material. The only change here is to the format, changing the first statement to the change is changing it to the format that we've adopted for views documents. So it's the language, it is the view of the National Commission. It's just a technical change in that respect. And the change between what was sent out and what you see before you now was to add the headings. And the reason for that was so that, given the discussion that took place previously with respect to what the view of the Commission or the recommendation of the Commission means, it was set out so that you would see what would be considered to be the statement of the view of the Commission versus that supplemental or background information. Let's move on to the next one. The statement here puts in bold, places the information in its original context. It was a recommended implementation strategy, or a part of the recommended implementation strategy. The thought was that we would include that language from the recommended implementation strategy as a statement of the view of the Commission, because it seemed most appropriately to fit that kind of structure. And then at the bottom, it talks about the necessity for funding and things of that nature. And so what we are proposing to do is to move those up from a recommended implementation strategy into a separate statement of the view of the Commission. There is another option that Jonathan, Lindsay, and I developed in the course of putting this together that may be more suitable. This is not really, this is a little bit problematic because it seems to be it seems to be more substantive in terms of, but it's trying to cloak itself quite honestly, as being a view by saying we're encouraging. But who are we encouraging, and to do what precisely is kind of left open. And so this was a tough part in the drafting process of turning this into a view of the commission. In the course of developing this, there was a thought that we thought had some merit to it, but it is certainly a substantive change, and we thought we would. I made the decision that we would go ahead and bring it forward so that people could see what that looked like and see which way they wanted to go. It may require that we take more formal action than we typically do on these reconciliation documents. But that is, this seems to, number one, it's more true to the views format. Number two, it encapsulates the concepts that were in the preceding slide, but it also expands the scope of the statement beyond the Department of Justice, which was the limitation of the directive and policy recommendation work products that we used to have. Obviously, this would be a substantive change, but I think it actually may make more sense as a views statement than trying to tinker with the preceding. I don't think that our bylaws would allow this to be the change made, but we could come back with a recommendation at the next meeting to amend the document to include this. And then the next slide changes the format only from a policy recommendation to a views document format and adds additional supplemental background for context. The language that you see added at the very bottom is actually taken from within the original report itself. We just changed the location of it because it seemed to fit better in that location. And this last part of the background, it makes the changes to the supplemental background material to make those statements more consistent with the views document rather than a policy recommendation. And at the very bottom, you'll note that that's where we cut the language from to paste in the preceding slide. Those are the changes that we made to come into to try to affect what the commission asked us to do the last time, which was to try to word this as a views document as opposed to the recommendation documents that we had earlier adopted. And if anybody has any questions, I'd be happy to try to answer them.
Congratulations, Matt. No questions.
Why do you think you need to wait?
Okay, so one of the things we could do is vote on it now in terms of moving it from recommendation to a views, or we could wait and discuss this further as part of the MDI discussion tomorrow afternoon during the subcommittee.
John and Vince, have you seen these changes?
Yes, of course,
Okay.
and I propose that we vote on them right now.
Okay, so if you can switch to my computer to So just to establish who's here and establishing the quorum, we have, because this is commission general business then, that we're not going over the details of the documents, right, but we're voting on this. This is to be changed from a recommendation to a views. Everybody can vote, ex officios as well. So Catherine Thurman has sent in her vote to me Everybody else, all the rest of the ex officios are here. We have several proxies, 4 proxies, as you note there. Suzanne Bell, unfortunately, at the last minute couldn't come, and Linda Jackson is not here, and she will be here tomorrow. What that means then is we need to have at least 20 yes votes because we just need a majority to be able to do this. So 20 yes votes out of 38 possible. So do we have a motion then for the vote? Yes? Second? Okay, so go ahead and do the vote then. This is the first one, which is accreditation of the MDI offices being moved from recommendation to a view. We should be able to get up to 38 if everybody pushes their, it all works. Okay. All right, we can go back and check who's missing there. Okay, everyone says yes for that, so that one passes. So we'll move, and then the second one is the certification of MDI investigators moving from a recommendation to a views. Anybody else? All right, we'll go forward with that then. Once again, everybody votes in favor of moving that from a recommendation to a views. So thank you.
Okay, nicely done, Matt. All right, let's, it's time for break, but we need time for them to set up for lunch as well. Is that correct, John? Yeah. So what about 20, 25 minutes if we can? I'll try to be back here before, I guess, noon would be great. Is that going to be enough time for the panelists? We can run on. We can go on. Okay. Yeah, let's do that. Let's be back here 5 till 12, please.